Hi, I'm delighted to be here. Very appreciative of the invitation to come to London and talk about these ideas with a London audience, get your input. Survivors of rape, sexual assault, sexual harassment, and so forth are speaking around the world, as I'm sure you are very well aware. And there's a real, we're in the, we're trying to do philosophy here in the midst of a social movement. One thing that we can note is that when survivors speak, their speech enters into somewhat of a media cesspool, right? The state of our mainstream media leaves a lot to be desired. Also, their speech sometimes enters into legal institutions, and in both cases, whether media or the courts, survivor speech is edited, it's interpreted, it's constrained, and it's spun. States and institutions in general are responding in ways that sideline the movement toward agendas that have little to do with really ending the epidemic of sexual violence, as I'll talk about tonight. So the question that I want to put on the agenda is, what can we learn from this moment? And how can we make our resistance more effective? So I want to start with a quote from Pierre Clastres, political anthropologist, in an essay on power and speech, who says the following: "To speak is above all to possess the power to speak. The exercise of power ensures the domination of speech. Only the masters can speak. As for the subjects, they are bound to the silence of respect, reverence, or terror. The man of power is not only the man who speaks, but the sole source of legitimate speech." Unquote. Now we might want to say, but this is a little extreme. It can't be true in our open liberal societies, not today. And yet. I'll argue that we do need to think through the relation of power and speech and the conventions we operate with about how authority and credibility and the legitimacy to speak work in our society in order to understand the current movement against rape and its reception. So I want to talk about the reception of survivor speech tonight. Me Too is, of course, not new. Collective efforts to call out the ubiquity of sexual violence in the lives of women, girls, children, prisoners, finally that topic has come under our agenda, and other vulnerable groups have been mushrooming steadily around the world since the 1980s. Didn't start in the West. And some of the most militant and big movements have been in places like New Delhi and Cairo and Mexico City today and Santiago, Chile. Right now, the whole of Latin America is experiencing reverberating demonstrations in major cities from Chile to Argentina to Mexico in particular, over femicide and rape. And their method of public displays of defiance and solidarity have been repeated elsewhere. If you haven't seen any of these demonstrations, just look it up on YouTube. You can look up anti-rape demonstrations in Chile, or you can look up "The Rapist in Your Path," which is one of the slogans that they tell. It's pretty incredible what's happening. All of these forms of social activism involve as a central feature the practice of survivors of sexual violation speaking out, speaking publicly, breaking long silences. I'm going to use in this talk both the term survivor and victim, and we can talk about that in Q&A if you want to talk about these terms. But both terms get used in various places around the world. What I want to say is that making survivor speech that involves making charges through judicial procedures is not, interestingly, central to the movement. There have been certainly some very high-profile judicial cases, certainly in the United States, but I know you've had some big ones here from Jimmy Savile on, and they've had a galvanizing effect on the movement, to be sure. But the movement itself does not call on every survivor to make formal charges. The courts in every country have proven to be unreliable. And this is true within institutions, when you have redress committees within institutions, as well as judicial proceedings. There's a lot of activism today around reforming the procedures of testimony. And in just the last 2 years in the United States, there's been some amazing reforms, such as the statute of limitations that has been changed from 7 years to 20 years and has opened a floodgate of charges, especially of child sexual abuse against the church, for example, the Christian church. But there's other religious institutions that are involved. So there are reform efforts to change judicial procedures, but that isn't the exclusive focus or even the central focus of the movement, which has instead been on changing the public sphere of discourse. Now, the tactic of victims coming forward is not always about making a charge against an individual perpetrator. You might think that if you read the news and you follow the cases of Harvey Weinstein and so forth. It is rather, though, about exposure of a socially accepted epidemic, an exploration of its dimensions, and an urgent call for new responses. Victim first-person accounts are compelling. But more importantly, I'm going to suggest here, it's not just about the affective intensity of the first-person report. It's also the case that victim reports provide information and analysis about the patterns that reveal the nature of the problem. And in speaking publicly, victims, of course, enact resistance, defying the stigma of shame and the likelihood that we will not be believed. And I would emphasize also that the problem with the reception of victim accounts, it's not always disbelief. I mean, you do have a problem of disbelief, as I'll talk about, but I think there are loads of members of the public who believe that the crime really occurred, but that it was not really that bad. One father of the accused rapist at Stanford University a couple years ago said, you know, why should my son's life be ruined for, quote, just 20 minutes of action, as he characterized it. Some believe in the victim's claims, but they continue to focus on the behavior or the dress of the victim prior to the assault, and many continue to reserve most of their sympathy for the accused on the grounds that, well, you know, he's a genius, or he's troubled, or he's so young with his whole life before him, now about to be ruined. So there's a gamut of common responses, some disbelief, but some belief with dismissal of the gravity of the victim's experience and its likely long-term effects on her life. Susan Bryson, who's another philosopher who's written a lot of wonderful things on rape, reported being constantly told she was, quote, just too sensitive for having long-term effects after surviving a brutal rape and assault in which her assailant left her for dead in a ditch. And there's a logic to these dismissive responses, Bryson says. She writes that, quote, as a society, we live with the unbearable by pressuring those who've been traumatized to forget and by rejecting the testimony of those who are forced to remember. And yet, victims are streaming forward. In the United States, the Supreme Court nominee Brett Kavanaugh was accused in riveting televised testimony. His accuser, Christine Blasey Ford, who was a professor of psychology, fairly high status type person. She was the subject of coast-to-coast vilification and threat, so much so that she had to move her entire family into a safe house immediately upon going public, as if she had threatened a mafia crime boss. Still, sexual hotlines saw an increase of 150% after her public vilification, and more accusers came forward in some of the high-profile cases in Hollywood, bringing Harvey Weinstein's accusers to over 100. The cost to victims who come forward and identify publicly remains quite high. They have lost jobs, careers, personal safety, relationships, and endangered their health. They face being stalked by their rapist. I've had students who've had their tires slashed by their rapist and have their friends threatened by their rapist. A woman who worked at Ford Motor Company and came forward with a claim of rape by one of her employers, lost her job, then lost her housing, then lost custody of her son, and now has to drive 8 hours to see her little boy. Others have been deported to countries in which they are not safe. The tactic of speaking out is not only one that has great personal cost, though, but it is regularly, as some activists put it, recuperated. And by this term recuperation, what they mean is that the speech of survivors can get misinterpreted and misused so that it doesn't challenge the real causes of the problem or shed light on the real causes of the problem. And it can be used as sensationalism in media markets hungry for profits. And most disturbingly, so that it can be used for agendas that have nothing whatsoever to do with ending sexual violence, most perniciously lending legitimacy to unilateral military invasions. My own country of origin is Panama, country in Central America, and it was invaded in 1989 by the US military at the cost of thousands of Panamanian lives, mostly of the poor. The invasion took place after a week of daily media coverage of a sexual harassment episode by Panamanian military forces against US soldiers and their wives. And this ran on repeat on television and radio, creating a kind of drumbeat of public support for what was called Operation Just Cause. That was the closest I've come to experience war myself in any direct way, as I spent many hours trying to reach my family who were crouching under dining room tables as MiG fighters strafed buildings in their neighborhoods. Needless to say, this operation of the US military had nothing to do with addressing the epidemic of sexual violence. So the question of the day is, how can we resist recuperation and make resistance more effective? Here is where philosophy can help. I'm sure you were wondering when I was going to get to philosophy. The recuperation of survivor speech faces at least 3 groups of obstacles. And in each case, I think philosophers need to be part of the conversation about how to overcome these. These 3 obstacles include, first, the problem of epistemic injustice, which has to do with knowledge, right? That's what the term epistemic means. So it has to do with how we judge who knows and how they know. The second is the problem of language and power, and the third is the problem of dominant discourses. So I'll explain briefly what I mean by each of these, how they work, and then I'll end with some ideas about redress and open it up for our discussion. So the problem of epistemic injustice, or injustice in the sphere of knowledge, who to believe. This is a very serious problem. There's some really good recent research in the United States on the problem of serial rapists, some of whom I know you have a horrific instance that has come to light recently in England. And some of these serial rapists, rape dozens, hundreds of victims. Well, it turns out that a number of the big-time serial rapists that have been caught in the United States were accused of rape the first, the second, or the third time that they committed a rape. Victims went to the police, made a report, described what happened, and the police did not believe them, wrote a half a paragraph on a piece of paper, filed it away, never investigated, never made a phone call, never knocked on a door. 80 rapes later, the guy gets caught, and they go back and find that they could have caught him much earlier. So the problem of not believing accusers has tremendous impact. In the West, women have long been behind the 8 ball on credibility judgments in a defensive posture before we've uttered a word. Accusations of rape, an 18th century lawyer argued, regrettably place, quote, the life of a citizen in the hands of a woman, unquote. His client, a wealthy New Yorker, was acquitted of raping a seamstress in his employ after a jury deliberation that took just 15 minutes. Ideas that correlate sexual identity with likely credibility have been promulgated throughout European history by the most influential philosophers. Socrates believed that women's attention to their dress was proof of our intention to dissemble. Aristotle declaimed the tenor and pitch of women's voices as a sign of insincerity and depravity. Rousseau advocated the educational segregation of the sexes so that boys could achieve their potential for independence of thought, while girls would remain properly deferential to the opinions of others. And Kant considered darkness of skin tone a contraindication of intelligence. Now, these ideas may seem extreme, but few educational curricula in philosophy departments or elsewhere spend the time necessary to debunk them. So as a result, I want to suggest they remain implicit but powerful parts of our mental landscapes. Still today, female news anchors, as well as candidates for political office, such as famously Margaret Thatcher, employ voice coaches to lower their tone and achieve a masculine depth. The normal tone of a female voice lacks authority. And Stephen Shapin is this wonderful historian of science and historian of ideas who's done a lot of work about who could participate in the emergence of the sciences as they emerged in the beginning of the modern era. And he's traced the putative justifications behind some of these ideas. He says, in early modern Europe, illiterate peasants were deemed too ignorant, Jews too cunning, slaves and servants too obsequious, and children and the mad too unreliable. Interestingly, nobles were also suspect on whether or not they were telling the truth, on the grounds that they were likely engaged in some court intrigue and schooled in the arts of persuasive dissimulation, which was true, right? The nobles were always had a knife somewhere on their person. The issue for women involved our purported sentimentality, but also our economic subordination and subsequent need to flatter and manipulate. And this idea remains powerful today. Witness the wide acquiescence to the idea that wealth enables political candidates to freely speak their minds. This is a problem we're having in the United States today, but I know it's not just in the US. The common charge that female accusers have economic motives, I think, also resonates with this old history. Achieving more epistemic justice for accusers means uncovering and critiquing these ideas. What is the basis of skepticism about a given accusation, and is it a legitimate basis? Does a person's economic condition, level of education, sexual history, profession, or social identity in any way justify presumptive skepticism? Obviously, the poor may certainly have a reason to hold their tongue, which means that when they take the risk to speak freely and make an accusation, it should be probably taken seriously enough to investigate. And of course, the wealthy have as much reason as anyone to lie, and they have the capacity to hire a lot of lawyers to do their lying for them. So we have to rethink some of these assumptions. One attempt to avoid problematic assumptions about the credibility of particular speakers can be through focusing on putatively objective features of their testimony, such as consistency. I've argued elsewhere, actually, in a piece in Aeon, do you say Aeon magazine? This is an illusory solution. Consistency is certainly a respectable, everyday form of judgment, but it is also subject to manipulation and the same form of negative prejudices I just listed. Defense lawyers are today focusing a lot on irrelevant consistencies or inconsistencies and then casting aspersions on accusers' memory, reliability, and integrity. In the Brett Kavanaugh hearings, Blasey Ford was asked a series of questions about the distance between her home and the house where the assault took place, about the names of all the people present in the house at the time, about the number of people present, about her reported fear of flying, her history of flights, the reasons for and destination of those flights. And these questions were designed to test Blasey Ford's credibility through testing her consistency in reporting details, even details irrelevant to the accusation she was making against Kavanaugh. And it was the answers Blasey Ford gave to these questions that were used to discredit her testimony about what Kavanaugh had done to her at that party. In a 2004 study into how juries assess victim credibility, Denise Lavore reports that the most frequently cited factor was consistency. Jurors want consistency in the statements by the accuser and also expect consistency in her post-assault behavior. Yet consistency about such specifics as the exact date of an event or the location of a house party are not always telltale signs of faulty memory about the encounter itself. One prosecutor explains that in her experience, quote, victims of relatively isolated offenses maintain a vivid, albeit distressing, recollection of the crimes. The victim may not remember what color shorts she was wearing when at 8 years of age, some 20 years ago, her uncle put his finger in her vagina, but the victim remembers that event with certainty, end quote. And there's further research that exactitude about peripheral features can waver, but not necessarily the principal features of the encounter itself. Sexual violations, whether of a violent nature or of a more manipulative sort, tax the victim's mental capacities. She or he is sometimes trying to assess the danger and calibrate effective options while maintaining a conversation and a neutral facial expression. It's like taking a math test while swimming in the open sea. One's faculties don't entirely shut down, but they're engaged in high-stakes multitasking. This can explain the fuzzy contours of some of our peripheral perceptions, even as we maintain with crystal clarity the memory of the physical violation and who did it. Memories of the identity of the perpetrator are reinforced after the fact by the need for survival, since we need to remember who to avoid. In the aftermath of events, the contexts in which conversations take place and the types of interlocutors we're conversing with can affect how precise we demand ourselves to be. And in some contexts, we may have good reason to be intentional in our misdirection. if we fear the person we tell may try to pursue revenge against our perpetrator. For example, in my own case, it took some time before, as an adult, I could establish the period of time in which my assaults occurred, since I'd kept silent for nearly 2 decades. I had to look at old pictures, recall related school events in order to piece together what grade I was in, and gather up the courage to direct some questions at my mother. Unfortunately, I could never forget the central events themselves. There's much work to be done in exploring the forms of epistemic injustice that accusers face today. In some cases, they're very old forms, but in others, brand new forms of recent invention plague the effort to achieve justice. Which brings me to the second topic, language and power. The self-described political anthropologist Pierre Clastres that I quoted at the beginning compared various types of societies for their varied conventions of speaking. Everybody doesn't do it in the way that we do. He says, speech and power maintain relations in all societies, but in different ways. In state-based societies, he says, power is the sole source of legitimate speech. The power of speech is detached from society as a whole. It's not distributed in society as a whole, not held universally. An accuser or defender may speak in court, yet the ultimate epistemic assessment of their words is held exclusively by a judge or a jury properly chosen, whose task is pretty severely circumscribed. Of course, this practice has not always been true throughout the European societies. As Michel Foucault reminds us, hundreds of years ago, the mad were considered epistemically privileged in a certain sense and employed as court jesters because of their ability to speak their minds, unlike those engaged in court intrigue. They were free of strategic agendas, alone capable of speaking truth to kings without fear of reprisal. They were outside the structure of power in that sense, but then made useful for the royal agenda nonetheless. Their speech was recuperated. Foucault suggests that we need to understand that the operations of power are not so centralized as we might imagine. Certainly in societies such as ours, courts increasingly rely on expert testimony from conventionally accredited authorities drawn from the social sciences, from the academy, from many sorts of judicially related institutions. There are relations of resonance between these diverse structures of authorization, but they're not organized in pyramid form. He also notes resonances between elements that may seem quite disparate. Here's an example. The confessional practices of the Catholic Church produce a structure of speaking relationships that exist today in other secular domains, sometimes with bad effect. So in the church, a penitent confesses to his confessor, not merely about his actions, but also, and perhaps more importantly, about his desires, his dreams, and his thoughts. The priest passes judgment and gives absolution through a certain number of rosaries to recite or similar practices. So in this speaking relation, the penitent provides the raw data without analysis or judgment. The latter are provided exclusively by the priest. The penitent has first-person privilege. They and they alone can report their innermost thoughts and feelings, but they have no privilege over the analysis of the level of venality, motivation, or cure. Some years back, a colleague and I did an analysis of representations of sexual violence victims in the television media, as this became a big commonplace focal point in the daytime talk shows. Inevitably, shows would begin with a riveting, emotional, first-person testimony close-up of victims to garner viewer attention. And since this topic was relatively new at the time, early 1990s, it did garner viewer attention. Victims were prompted by a series of questions by the show hosts, generally sympathetic, at least in the beginning. But also, sometimes the show hosts would ask skeptical questions that they believed their viewers might want answered. And in this way, the hosts sort of positioned themselves as the representative of the public, just as the priests were representatives of the church or of God. Yet then a third figure almost inevitably appeared on these TV shows, the dispassionate, objective psychiatrist or psychologist who could explain the symptoms of the victims, interpret their speech, and offer analysis. This role was not accorded the victims themselves. So in this way, the confessional structure of the church was replicated almost exactly in a secular space where authorization is given by educational credentials rather than religious ones. But in both cases, whether penitent or victim, the person giving the first-person testimony is given very limited epistemic privilege. They're put on the stand to be judged and analyzed by others. To understand such scenarios and to begin thinking about what's wrong with them, we need an analysis of language and power. How are the two related? What are the ideas about the ways in which certain configurations of speaking relationships can ensure truthfulness and reliability? Who may speak about what under these conditions, and what may be restricted from seeing the light of day? For a long time, this list of restricted speech has included accusations against husbands, fathers, mothers, the rich, the church, the psychiatric establishment, for example, and these are still the hardest to prove. So finally, the problem of dominant discourses I want to look at. And in the last one on language and power is looking at the structure of the speaking relations and who may say what and who may give analysis and judgment and who may not. In this problem of dominant discourses, I want to talk more about content than the structure of speaking relations or of authoritative power. So the idea of discourse is that our speech enters into a swirl of beliefs, ideas, concepts, and framing assumptions that produce the familiar way a society has of forming questions. Discourses cannot determine what is taken to be true. They can't make the moon made of green cheese, but they concern what is taken as having truth value. We still have to produce evidence for a claim, but which claims do we take to be intelligible and plausible enough to generate the search for evidence? For a long time, accusations against fathers, for example, were not taken as plausible in a prima facie way, and in fact taken as evidence of madness by the person making the charge. Now here I want to raise another problem in our current discourse, which I think is the hegemony of the concept of consent, which today serves as the key criterion used to distinguish morally blameworthy from morally blameless sex. Rape, sexual assault, and sexual coercion are defined in our societies today in terms of consent. And there's a lot of reasons for this. I mean, given sort of the fact that bondage has become a popular practice among some sectors, bruises and even injuries, of course, cannot suffice. So what we want to know is whether all parties consented. Consent has not always been the principal focal point, but in the age of decreased religiosity and an acceptance of sexual pluralism, I think the question has shifted from what a couple is doing and judging what a couple is doing to simply whether or not they're all consenting. So this concept has really become hegemonic, I'd suggest, well beyond the legal arena. It's used in the courts, but it's also sort of the central concept that largest sectors of the public use to distinguish morally problematic sex. Its history is instructive. A century ago, laws referenced seduction rather than consent. roughly, seduction equaled breach of promise, as when a woman is pregnant out of wedlock, had engaged in sex under the promise of lawful marriage, yet found herself alone and bereft. This was a crisis, of course, since in those days she could be legally fired, turned out of her housing, and thus her crisis was a social crisis, which seduction laws were designed to solve, get the man to marry her, and society's off the hook. Interestingly, seduction laws put the onus on men to explain themselves. Their actions and promises were the focal point of trials. Seduction law pretty much ignored women's own desire, will, and consent. The focus was on men. The movement to replace seduction laws with consent laws was supported by a lot of men, some of whom were probably motivated to take the onus off of them in court. Any man having sexual relations out of wedlock was in danger of being charged. Seduction laws were, of course, not foolproof, though. A man could marry a woman to avoid prison and then still, shortly thereafter, leave town. And seduction laws ignored the physical, emotional, or economic coercion of women. They were designed to force men to marry their pregnant girlfriends without much concern for how the event occurred. So consent looked to be a good alternative as a means to get at what society should be truly concerned about and how we should understand what is most centrally of moral concern in such cases, which is not the issue of lawful marriage. Yet, consent shifted the focus of trials on women to prove they did not consent, and hence their attire, sexual past, and demeanor became considered legitimate subject matter for the judgment of judges and juries. If we think about the issue of consent as a feature of resonating discourses, we can assess its problems. It resonates with the contract tradition, as a number of philosophers have pointed out, in Western market societies in which we make promises to deliver goods or services. To consent is to make a sort of contract. And it is, there are these new apps. I don't know if they're in England. I was asking people last night, and nobody had heard of them over here, but in the United States we have these new apps you can have on your phone in which the person you're about to have sex with can register their consent in writing, so you have a record before you jump into bed. I wonder what the real purpose of these things are. I mean, so it is a kind of contract. In this practice in which consent is a kind of contract or promise to deliver a service over a specified time frame, I think there's phenomenological problems. It may give the person who receives the consent the idea that they are owed sex, as Anne Cahill has pointed out, making it difficult for the person who consented to change their mind. But of course, the language of consent and of contracts is phenomenologically inadequate. It's experientially inadequate, in other words, to the nature of sexual experience, in which desire is not something you can guarantee will be sustained. You can promise to perform, but you can't promise to sustain a desire, a state of arousal, right? When the focal point is the consent of the woman in the encounter, this replicates and resonates with old gendered ideas that men ask and women answer, that males are sexual aggressors and females are receptive. And so the focus of consent can actually reinforce heterosexual norms in which femininity is associated with receptivity and caring, while masculinity is associated with sexual needs and dominance. Most importantly, perhaps, we know that there's structural conditions that can predetermine consent. Consent doesn't necessarily mean you're expressing your autonomous will. There's economic dependence at work and at home. also status and ranking differences that produce what Jeffrey Gautier calls the choice situation of the oppressed class. Choose this low-paying job or that one, this abusive situation or an end to your career. In research by Nicola Gavey, women report that they consent in order not to be raped. Now get your head around that for a second. What does that mean? Here, clearly for them, consent is a way to avoid being beat up, right? It's a way to lessen physical harm and trauma. However, how far we have come from a concern with women's desire, will, and sexual pleasure. I'm not saying consent is unimportant. What I'm arguing is not that it has no usefulness, but its position in our discourse as taken to be the obvious, unassailable determinant of what is morally blameless versus morally blameworthy has to be critiqued. And if you're watching the news from the United States, you know that this is the cornerstone of Harvey Weinstein's defense. He's arguing that his accusers were actually consenting. And he attempts to provide this proof by their friendly emails and their relations post-assault. And in this way, he's wielding consent as a weapon by which to remove the structural power relations from the frame of analysis. Foucault's concept of discourse is, I think, very useful here because he notes that discourses are not simply collections of statements. They also involve practices, forms of subjectivity, ways in which institutions are organized. So our sexual practices and our sexual lives are now affected by this hegemonic conception of consent, for better or worse. And our institutions make this their sole concern. So to conclude then, what are we to do? We must come to understand the epidemic of rape as connecting up to many central features of liberal societies, from the way we police and discipline the speech of the disempowered, to the way we allow their speech to be taken up, used, and recuperated by those higher up in the food chain of institutional power. When survivors speak, their speech most often must pass through this sieve, through the media or the legal domain, in which it's interpreted and judged by others. These domains, like the media, protect themselves with the cry of free speech and the denunciation of censorship. We've got to think past these stumbling blocks and reconsider what would really be required to free up the speech of the subordinate. Survivors have been creating our own venues of communication for a long time, from anonymous accusations on the backs of bathroom stalls to the use of social media today with hashtags like Talk About It. They've forced their way into the public sphere, demonstrating dancing en masse in Latin America, or just creating spray paint outlines of victims on college campuses and getting expelled for it. The idea here is to find and make our own venues of speech, unedited by others, in which victims can be theorists and analysts, and authority and credibility can be transformed on our terms. It's not an attempt to segregate, but to provocate in the public sphere. Thanks very much.